So, can you copyright AI generated art? Well, let's talk about it. Hi, Attorney Danielle here, and I talk all things business, tech, law, and pop culture. And today we are talking whether AI generated art is offered copyright protection from the U.S. Copyright Office. Let's get started. So to begin, what is the U.S. Copyright Office? The Copyright Office is the federal agency responsible for managing the copyright registration system and providing guidance on copyright and related issues to Congress, other agencies, and the federal judiciary. And over the course of more than 100 years managing the copyright registration, the office has gained significant knowledge and proficiency in distinguishing between works that qualify for copyright protections and those that do not. With that being said, the Copyright Office released their copyright registration guidance, works containing material generated by artificial intelligence. And they released this due to the quote-unquote use of sophisticated AI technologies that have the ability to create expressive material, or AI generated art. So what is AI generated art? I'm glad you asked. I'm so glad you asked. Simply put, AI generated art is digital art that is created using special computer programs that can learn and make decisions like the human brain. These programs can be trained on existing art or create new and unique pieces. This type of art can be images, video, music, or writing. AI-generated art is a new and exciting field that raises interesting questions about art and technology, which is the reason why the Copyright Office released this guidance. The office has stated that these technologies, often described as generative AI, raise questions about whether the material they produce is protected by copyright, whether the works consisting of both human-authored and AI-generated material may be registered, and what information should be provided to the office by applicants seeking to register them. So, what does that mean? So the Copyright Office is like, look, AI is going crazy, and you have the chat GPTs and all these other chat bots, and you guys are creating stuff and you're trying to get your works protected by US copyright law, but there's one issue. No human created it. And on a general level, we can't have that. So to fully understand what I'm talking about, let's get into the human authorship requirement. What is the human authorship requirement? According to the Copyright Office, it is firmly established that copyright law can only safeguard material that is created by humans. This is primarily because of the definition of author used in both the Constitution and the Copyright Act specifically excludes non-human entities. And the office has created its registration policies and regulations according to the relevant legal and judicial guidance. So here's an example. The Supreme Court rejected the argument that photographs could not be protected by copyright because they were not writings and were not the product of an author. The court held that the copyright clause of the Constitution permitted Congress to extend copyright protection to photographs that were the result of original intellectual conceptions of the photographer. The court defined author as someone who originates or makes a work and repeatedly referred to authors as human beings. Can't believe this is a thing. The court's language in this case has been cited as evidence that the Copyright Act does not extend copyright protections to works created by non-human entities, such as computer programs or artificial intelligence. Furthermore, the fact that the copyright protection is limited to works of authorship is also a conclusion that has been reached by federal appellate courts as well. The policy statement specifically references the Ninth Circuit, where the court ruled that a book that features content authored by non-human spiritual entities is only eligible for copyright protection if there is human selection and arrangement of the revelations. Additionally, the court determined in another case that a monkey is not capable of registering a copyright for photographs it captures with a camera, since the Copyright Act uses terms as children, widow, grandchildren, and widower, which all suggest humanity and exclude animals. So at this point, I already know, like, y'all just like, okay, what's the takeaway here, Danielle? In order for your work to be offered copyright protection, it must have been authored by a human. So, Attorney Danielle, what if part of the work is created by a human and the other part was created by AI? Good question. Good question. To answer that, I have to now shift into a discussion on how the U.S. Copyright Office applies the human authorship requirement. So, how does the U.S. Copyright Office apply the human authorship requirement? The first question is whether the work is primarily the creation of a human author with a computer or other device simply acting as a tool, or if the elements of authorship within the work, such as literary, artistic, or musical expression, or selection and arrangement of the content, were conceived and executed by a machine rather than a human. Again, just to clarify, what does this mean? So let's look at it this way. The question should be, who primarily created the work, the human or the computer? So was the human the primary author? Meaning, was the human behind the literary, artistic, musical expression, or the selection and the arrangement of the content? Or did the computer do it? The final determination will depend on the unique circumstances surrounding the use of the AI tool and how it was employed to produce the final work. And cases such as these are always conducted on a case-by-case basis. So let's look at some scenarios in the policy statement. Scenario 1. If a work's traditional element of authorship were produced by a machine, the work lacks human authorship and the office will not register it. So here's an example. If I instruct a text-generating technology such as ChatGPT to write a poem about copyright law in the style of the rap group Migos, I can expect the system to generate text that is recognizable as a poem, mentions copyright, and resembles the Migos style. But here's the issue. It is the technology itself that will decide the rhyming pattern, the words, and the structure of the poem. The AI has the creative control, not the human. So basically, when an AI technology determines the expressive elements of its output, the generated material is not the product of human authorship. As a result, that material is not protected by copyright and must be disclaimed in a registration application. Scenario 2. In other cases, a work containing AI-generated material will also contain sufficient human authorship to support a copyright claim. The office has stated a human may select or arrange AI-generated material in a sufficiently creative way that the resulting work as a whole constitutes an original work of authorship. Or an artist may modify material originally generated by AI technology to such a degree that the modifications meet the standard for copyright protection. Here's an example. Imagine an author who wants to write a novel but is struggling to come up with a compelling plot. The author decides to use an AI program to generate random plot points and story ideas. The AI program generates hundreds of different ideas, but the author selects only a few that seem interesting and arranges them in a unique and creative way. Using these AI-generated ideas as inspiration, the author writes a novel that tells a completely original story. Now, while the individual plot points may have been generated by an AI program, the resulting novel as a whole is considered an original work of authorship because the creative selection and arrangement of the AI-generated material. And while the individual plot points may have been generated by an AI program, the resulting novel as a whole is considered an original work of authorship because of the creative selection and arrangement of the AI-generated material. In these type of cases, copyright will only protect the human authored aspects of the work, which are independent of and do not affect the copyright status of the AI generated material itself. In this example, even though the author used an AI program to generate some of the ideas, the resulting novel is considered original because of the author's creative selection and arrangement of those ideas. And as the creator of the novel, the author has the right to claim copyright and prevent others from using or copying the work without permission. So in summary, in determining whether AI-generated art can be offered copyright protection, ask yourself the following question. Was the human the primary author or the computer? If the art's traditional elements of authorship were created by the computer, the work lacks human authorship and will not receive copyright protection. But if the human has creative control over the AI-generated art, it possibly can be considered an original work of authorship. And there you have it. Well guys, that's the end of this video. If you found this content helpful, please don't forget to like and subscribe. But in the meantime, always remember to do what? Pay attention to the legal details. Bye.